welcome to Requiro. I got a microphone. Yay! You probably guys saw this in my short, but I got a microphone. So very exciting stuff. So now you guys don't have to deal with me holding my little lapel mic. So yeah, thank you delayed Christmas gift card. That's what I bought this with. I'm not changing this off rainbow mode because rainbow mode is so much fun. Sorry for the continuity. Anyway. Today we are going to be talking about the updates for the Luigi Mangione case, and this will be in order of the information given to us. So we are going to be first starting off with the big documents I wasn't able to cover in my last video on Luigi Mangione just because of time, because that video is 3 hours long. Yes, I'm going to keep quoting it's 3 hours long until the end of time. We're going to be starting off with those documents, and then we're going to go on to the rest of the updates since that last video on Luigi Mangione. In my big video on everything you need to know about the Luigi Mangione case, someone did mention saying, hey, you said Transylvania instead of Pennsylvania, so I do want to say I'm so sorry. Anytime if you look in that video and I say Transylvania, I mean Pennsylvania. I'm sorry, I don't live in the United States. I do have that thing called speech dyslexia, where if you hear words that are very similar to each other, you will get them muddled up, so I do apologize. So anytime in that video I say Transylvania, I mean Pennsylvania. Again, I'm so sorry, my mistake. And same thing in this video. One thing I do want to mention here is if there's anything I missed or I didn't cover or I got wrong or anything, please let me know and I'm sure I'll bring it up in my next video or pin it in the comments down below. I am one person working on this. There is no team or anything. Look how small this channel is. I'm just a 24-year-old with a microphone attempting to do a podcast. That's all I am. Also, another thing I want to add here is all the sources and everything I used in this video is going to be in this week's episode on the website. I do recommend to do your own research on all this. As recording this video today, Australian time, it is May 7th, but in the US today is technically May 6th, and it's Luigi Mangione's birthday. So if he ever watches this, I don't think he ever will. Why would he watch a video of a random 24-year-old talking about his case online? Anyway, if he ever does come across this or anything, happy birthday. Anyway, my hair's slightly less green, and now let's get into the video. So today, as I'm recording this, today is May 7th, 2025 Australian time. So the first big update here now, and before we get into the video, on April 18th 2025 Luigi Mangione was officially indicted, and then on the 25th of April 2025 Luigi Mangione had his official court hearing. I'm gonna put the things that I really want to mention up on screen here like I said in my last video, and we'll go more in depth with all that later on in the video, and I don't want to repeat myself, so here it is. Luigi Mangione pleaded not guilty in the state of New York with the New York charges, and apparently, eyes of witnesses, Luigi Mangione was in very good spirits. He was getting along with his legal team very well, and there wasn't any cameras or photos or anything, but we do have drawings and quotes from people saying how Luigi Mangione looked. So according to witnesses and the drawings we gotten in the courtroom, apparently Luigi Mangione was wearing a light yellow, beige type of jumpsuit, prison jumpsuit. I think that's what it's called. And because it's spring and it's a lot warm over there, so he wasn't really wearing a jumper with a white button-up shirt. And according to some also other pictures, he's not in any vests or chained up or anything, so I found that quite interesting. Apparently his hair looked like this. Hi, it's voiceover me. So this is strictly just for the people that are just listening to the video. So his hair currently looks like what it did in 2020. His hair's a lot shorter, a lot more neater now compared to his last court appearance. I think his barber did not know how to work with curly Italian hair. Anyway, and for the people who say who cares about his hair, the answer is We need to know. We need to know he's taking care of himself and looking sharp. Okay, back to the video. Hi, it's voice of me. So I'm just correcting the little card thing I have on the side from my last week's video, because around that time there was a lot of things coming out and it wasn't really like verified between it was when he was indicted or when he had his court hearing. Apologies about that, there was a lot of things going on and a lot of things were like jumbled, so sorry if I got those dates wrong, but I did fix that little card thing I have on the side that I do for dates for this. Okay, welcome back. We'll talk about that more in depth when we get up to that point in the video. Again, if you guys want to fast forward from the 2 documents we're going to be reading from my last video, I wasn't able to cover, just fast forward in the video, there will be timestamps, so go ahead, I don't mind. Okay, so these are the 2 documents I wasn't able to cover in my last video because, again, timing.
District Attorney, County of New York, 1 Hogan Place, New York, NY 10013 212 335 9000. Alvin L. Bragg Jr., District Attorney, March 25th, 2025. Hon. Gregory Caro, New York State Supreme Court, Part 32, 100 Center Street, New York, New York 10013. IJAT 32 1025 Re. People v. Luigi Mangione. Indictment No. IND 75657-24. Dear Honorable Gregory Caro, we are writing in response to counsel's letter to the court dated March 19, 2025. Defendant draws the court's attention to several matters, including 1. Requesting a 78-day extension from April 9, 2025 until June 26, 2025 to file his omnibus. 2. Seeking to preclude the people from filing a protective order. 3. Seeking the court's position on defendant being provided a personal laptop while in federal custody. And 4. Updating the court regarding discovery disclosures to this point in the case and demanding further discovery. The people address these matters in turn. Specifically, for the reasons set forth below, the people oppose an extension of defendant's time to file motions, ask that the court reject defendant's meritless motion to preclude the people from filing a protective order, and request that the court deny defendant's application for provision of a laptop for use in custody. The people further make the court aware of an incident that occurred prior to the last court appearance on February 21, 2025. Either court's motion schedule should remain the same. The court's motion schedule should not be extended, as defendant fails to provide a legitimate basis for needing additional time. The court ordered defendant to file motions by April 9, 2025, for the people to respond by May 14, 2025, and adjourned the case to June 26, 2025 for the court's decision on defendant's motions. In seeking a brief extension of the motion schedule, defendant asks for an additional 78 days until June 26, 2025, the date that the court set on February 21, 2025 for its decision. Counsel's primary reason for asking the court for another 2.5 months to file motions rests on a conclusory, unsubstantiated claim that the defense has not received enough of the discovery necessary to be able to prepare motions. We have set out in the attached discovery list, Exhibit 1, a list of materials provided to date with the relevant dates they were provided. In summary, the people had served on defense counsel the following by February 21, 2025, the date the motion schedule was set, between January 6, 2025 and January 8, 2025. The people served on defense counsel statement and identification notice pursuant to CPL 5710.30, 1, A, and B, as well as several body-worn camera videos, transcriptions of body-worn camera, dash camera videos, interrogation video, and video surveillance containing known statements of defendant to law enforcement, on January 22, 2025, the people served on the defendant virtually all raw video surveillance footage collected by New York City Police Department NYPD during the course of its investigation. 1. Certain lab reports for forensic testing done by the NYPD lab, including latent print development, trace evidence analysis, and ballistic testing. The NYPD latent print section case file, a data extraction of the cell phone defendant dropped as he fled the crime scene, and certain phone records obtained by warrant, on February 21, 2025, the people served on the defense all police reports and other discoverable material, including photographs and body-worn camera footage, received thus far from Pennsylvania law enforcement authorities, the NYPD crime scene unit reports and photographs, the forensic files from the Office of the Chief Medical Examiner for the DNA testing conducted for the case, all NYPD lab reports, notes, photographs, and the underlying scientific testing data, the autopsy report and photographs, the grand jury testimony of all non-civilian witnesses, and all grand jury exhibits. Certainly, as of the date the court set the motion schedule, defendant was in possession of sufficient items of discovery necessary to file motions, including 1. All statements of defendant to law enforcement the people intend to introduce at trial, as well as all related one notably, the video surveillance footage provided excluded certain video surveillance being reviewed for potential reductions and video surveillance obtained from certain locations in bulk, presently being reviewed to determine whether contains footage related to the subject matter of the case. These reports and body-worn camera recording the circumstances of any given statement, to the extent it exists. 2. Photographs and written recordings of all physical evidence recovered from both defendant as well as locations of interest during the course of the investigation, as well as all related police reports and body-worn camera recording the circumstances of the recovery of the property, to the extent it exists. 3. Identification notice, pursuant to CPL Section 710.30, 1b, and People v. Purdue, as well as police reports reflecting the circumstances of any identifications of defendant, whether subject to the aforementioned notice provisions or not, and 4. The grand jury testimony of all non-civilian witnesses, and all grand jury exhibits subject to limited redactions. Clearly, defendant had access to the forms of discovery needed to assess the validity of and or file any suppression motions and motions challenging the sufficiency of the evidence before the grand jury, as Your Honor agreed. During February 21, 2025 court appearance, upon the people updating the court on the status of discovery, the court noted that counsel had received enough discovery to be able to file omnibus motions. See Exhibit 2, February 21, 2025 minutes page 7, it appears you have enough. The court was absolutely correct in finding that the materials the defense had in its possession were indeed sufficient to allow the defense to prepare motions. Nothing has changed since the court's finding to reverse its decision. In fact, the defense is in a far better position today to make motions than it was on February 21, 2025. On March 7, 2025, the defense provided the people with a hard drive, and the people provided the defense with the next batch of discovery by the following business day, March 10, 2025. As delineated in Exhibit 1, this batch of discovery contained all NYPD detective case reports, DD5S, and their corresponding attachments received to this point in the investigation, NYPD arrest paperwork, including the voucher paperwork associated with the physical evidence recovered during the course of the investigation, and copies of the search warrants, court orders, and their corresponding affidavits made as of that date. In addition, on March 11, 2025, the people furnished a copy of the People's Automatic Discovery Form, ADF, outlining particulars, including a list of scientific and medical reports, a list of electronic recordings, a list of certain electronic information obtained by subpoena and search warrant, and an accounting of the tangible objects obtained from or possessed by defendant. All told, the people have provided counsel with over a terabyte of materials. Despite the concededly voluminous discovery production, the defense dubiously claims that they are not in a position to even decide which motions to file. Def. Letter at 6. In support of this assertion, the defense continually refers to a lack of civilian witness discovery, or civilian witness records. See Def. Letter at 1. All defense has yet to receive any civilian witness discovery, and 11. Prosecution has yet to provide a defense with any non-law enforcement discovery, including civilian grand jury testimony and NYPD DD5S. See also Def. Letter at 2. 7. However, quite the opposite is true. First, defendant has access to the vast majority of police reports documenting interviews of civilian witnesses, including all police reports obtained from Pennsylvania law enforcement, NYPD Detective DD5S, the NYPD complaint report, and the memo books of responding NYPD officers. the only 2C def, letter at 1, 5, and 6. Information redacted from these disclosures are the names and identifying information for certain civilians, reasonable redactions to address valid concerns for witness safety. Contrary to defense counsel's misleading characterization of the discovery provided, this is not an utter absence of any civilian witness discovery or even an absence of civilian witness statements from the NYPD DD5S. Defendant has access to information and evidence provided by civilian witnesses to members of the Altoona Police Department, members of the Pennsylvania State Police, and members of the NYPD, both patrol officers and detectives. To be sure, the people have not provided the testimony of civilian witnesses before the grand jury. However, civilian witnesses constituted a fraction of the testimony before the grand jury. To clarify this for the court, the civilian witness grand jury testimony made up a grand total of 4 of the 23 witnesses called before the grand jury, one of whom was called to authenticate certain video surveillance. Additionally, the people have provided copies of every exhibit entered during the presentation, including those entered through civilian witnesses. Upon the court's request, the people can furnish the unredacted grand jury testimony for in-camera review. As the court would see, the presentation primarily rested on the testimony of non-civilian witnesses and other independent evidence. The redactions at issue were narrowly tailored to shield certain information or material that identifies or tends to identify civilian witnesses and the extent of their cooperation, based on very real concerns for witness safety, as discussed infra. Rather than writing motions as ordered by the court, defendant exaggerates the extent of common sense redactions to further defendant's aim to delay these proceedings. The defense further protests that they must have access to a copy of the electronic devices seized from defendant in order to file motions to controvert. As an initial matter, the people are not withholding this discovery, but rather, as outlined for the court on the last calendar date, have focused our review, redaction, and disclosure of discovery on the items needed for defendant to file motions, which we have. It is uncontested that the people served on the defendant the search warrants and search warrant affidavits related to the seized devices. Thus, defendant has all that is necessary to move to controvert the search warrants. Defendant's application is devoid of any explanation as to how the content of the devices bear on any potential motion to controvert. In addition, nothing on these devices was introduced in the grand jury. Even if defendant determines that materials in future disclosures bear on a suppression issue or a motion to controvert, the defendant may supplement his motions at a later time. The court made this clear to the defense when the defense sought a delay with very similar arguments on February 21st, 2025. See Exhibit 2, February 21st, 2025 minutes page 11. In sum, the defense's application to further delay motion practice must be denied, since their letter does not make out the necessity for such a delay. Defendant's baseless request to preclude the people from filing a protective order should be denied. Counsel's request to preclude motions for protective orders as late is without a basis in law or logic. In fact, the explicit language of CPL Section 245.70 provides that, upon a showing of good cause by either party, the court may at any time order that discovery or inspection of any kind of material or information under the article be denied, restricted, conditioned or deferred. CPL Section 245.70, 1. The defense does not offer any contrary statutory or case law authority for the remedy they seek. Instead, the defense makes a generalized claim that this should be the consequence for a violation of the discovery statute. As the people informed the court and counsel at arraignment, the volume of discovery materials is extensive and there are time-consuming redactions to be made in these materials. Thus, the people alerted the court and counsel at the earliest possible time of the necessity for redactions and the voluminous nature of the discovery, something that the statute specifically contemplates when setting out the timelines for disclosures of discoverable items. See CPL Section 245.10, 1, 5b. The people do not believe that providing 1 terabyte of data constitutes a discovery violation. The alleged violation is that the discovery production has extended beyond the statutory timetable, an unavoidable reality in this case that has been known since the case's arraignment. The statutory timetable, of course, was written for the average case. Simply put, it does not contemplate a case of this magnitude and discovery of this volume. Even so, Article 245 leaves to the court the discretion and responsibility to adjust timetables, in light of the realities of the case. CCPL Section 245.70(2). The court has done just that, requiring status updates from the people and deferring the motion schedule in the first place to ensure the defense had adequate discovery. That appropriately balances the unique challenge of discovery in this case that the people brought to the court's attention at arraignment. Moreover, even if the court finds that the people have exceeded the statutory timetable, a sanction is utterly inappropriate in this context. While the defense does not cite to it, the discovery laws contain specific provisions for sanctions related to any claimed discovery violation. Art 245 explicitly provides that any sanction imposed by the court for belatedly disclosed discovery must be appropriate and proportionate to the prejudice suffered by the defendant. CPL Section 245.80(1). As showing of prejudice is a required consideration, the level of prejudice the defense establishes, if any, speaks to the severity of the sanction, or lack thereof, that must be imposed. If the defendant fails to establish any prejudice at all, then any sanction imposed would be inappropriate and disproportionate. Here, if we are to read defendant's request as a proposed sanction, the proposal is far from appropriate and proportionate to any claimed prejudice. In fact, defendant fails to claim any cognizable prejudice as the defense has gotten what they asked for. As the court may recall, at defendant's arraignment on December 23, 2024, defense counsel requested immediate expedited discovery. See Exhibit 3, December 23, 2024 minutes page 5. The court indicated that the people should expedite discovery ID. At 8, the people put the court on notice of the volume of discovery at issue, spanning multiple jurisdictions, and the need to review and redact, and the court noted when adjourning the matter that the people should give more rather than less discovery by the next date, ID, at 8-9. As a result, the people's initial focus was on reviewing and providing large swaths of discovery to the defense as soon as practicable, rather than filing a motion for a protective order, which would trigger hearings. Because of legitimate concerns for witness safety, the people reviewed materials before turning them over to defense, making necessary redactions. The preparation for the production was extremely time-consuming. Nonetheless, the people kept our promise to the court and counsel to do our best to expedite as much material as possible. Moreover, even assuming arguendo that defendant was able to show prejudice related to a discovery violation, defendant seeks an inappropriate and extreme sanction, while defendant's attempted litigation of the merits of a protective order are premature. Even a skimming of the news media, which defendant often cites to highlight the concern for the safety of individuals who cooperate with the people's investigation. Defendant's conduct has directly led to several instances of harassment, backlash, and death threats against both individuals who have cooperated with the investigation as well as prospective witnesses, including employees of the Altoona McDonald's where defendant was arrested, 3 members of the Altoona Police Department who simply did their duty, 4 healthcare professionals both associated with United Healthcare and others in the industry generally. 5. The acts of those who sympathize with defendant show that nobody associated with the case is off limits to acts intended to intimidate and coerce. As a result, the people will seek to protect the identities of all civilian witnesses and the extent of their cooperation with the instant investigation. Despite defendant's blanket claim that no basis exists for any protective order, counsel is well aware of the concern for witness safety, witness intimidation online and via social. 3C Taylor Herzlich, Google removes 1 star McDonald's reviews after worker turns in Luigi Mangione, United Healthcare CEO Brian Thompson's alleged killer. NY Post, December 10, 2024, https://nipost.com/the10th of December 2024/business/Google removes bad McDonald's reviews after worker, reports Luigi Mangione reporting online reviews calling McDonald's employees rats and a protester at the Altoona McDonald's, Jessica Batelho, rats everywhere, backlash hits McDonald's after arrest of CEO shooting suspect, KFOX14, December 9, 2024, https:// kfoxv.com/news/offbeat/rats everywhere /hits McDonald's after arrest officer shooting suspect fast food rodents allegations Altona, Pennsylvania, New York Police Department Luigi Mangione 4C Bill Shannon et al. Altoona police say they're being threatened after arresting Luigi Mangione. WTAJ, https://www.wtaj.com/news/local news/Altoona police say they're being threatened after arresting Luigi Mangione. Rrom et al., McDonald's workers who identified Luigi Mangione get private security. Newsweek, December 12, 2024, https://www.newsweek.com/McDonald's worker Luigi Mangione private security 1,999,217. 5C Eric Ortiz et al. Wanted CEO posters and other threats emerge after Mangione arrest. NBC News, December 11, 2024, https://www.nbcnews.com/news/us/wanted posters threats Mangione arrest United Healthcare Ugnal 83,867, discussing threats to healthcare professionals, including a call to blow up a United Healthcare building, a call asking for details about an employee's children, and a call to an employee stating this is why All's CEO was shot, and if you're not careful, you're going to be next. Media, and the chilling effect that it would have on the cooperation of vital witnesses should their identities and contact information be disclosed to a defendant well in advance of trial, particularly in a case of this nature. 6. It would be illogical and absurd for a court to endanger witnesses or victims by refusing to consider a prospective protective order due to an alleged failure of the prosecutor to provide discovery. The people intend to file a motion for a protective order on limited items in the coming weeks. For the reasons stated above, the defendant's application must be denied. 3. Defendant's request for a specially formulated laptop should be denied. The defense further asks this court to provide its position regarding providing defendant with a personal laptop to review state discovery. For subsequent litigation in federal court, the people submit that the court should deny defendant's application for the laptop and reject defendant's assertions that he is being treated unfairly. We acknowledge that counsel sought our approval of a specially formulated laptop, and the people declined to consent to defendant being provided a personal laptop. Contrary to counsel's claim in the letter, the people's understanding upon conferral with the United States Attorney's Office for the Southern District of New York, USAO SDNY, is that they have not taken a position on whether they would consent to the specialized computer for review of discovery. In fact, the USAO SDNY has not provided discovery in the matter in any form. The USAO SDNY simply says they would not object if we agreed to this special laptop for review of state discovery. However, we do object for the reasons set forth below. First, defendant fails to show a necessity for defendant to receive a laptop in order to review discovery. Upon conferral with the Metropolitan Detention Center, MDC, the people learned that MDC generally objects to the provision of laptops to inmates, and for that reason, very few have them. Notwithstanding that, the people were informed that the defense can petition a court to order the provision of a laptop, arguing, among other things, that a defendant has inadequate access to discovery or a laptop is necessary for an imminent trial. However, these circumstances are not present here. MDC assured the people that this defendant has ample access to desktop computers where he is housed to review discovery, conduct legal research, send emails, and draft motions. They informed us that defendant further already has access to paper discovery, which he is allowed to keep on his person and review. Moreover, the digital discovery is the exact type of discovery that is of concern in this case. Given the impossibility to review and redact all raw video surveillance obtained with respect to this case, there is a concern that should defendant have unfettered access to video. 6. See testimony before City Council Committee on the Justice System by Executive Assistant Karen Friedman Agnifilo, February 27, 2018, https://www.manhattanda.org.wp, content/upload/2018-02. 2. 27.18 CC Discovery Written Testimony PDF. Surveillance, He may disseminate images of civilians captured on said video surveillance. As the defense notes, the people are concerned about the sensitive nature of the materials at issue prior to the litigation of a protective order. Meanwhile, counsel contorts the people's objection to defendant receiving a special laptop into yet another hollow excuse for delaying their filing of motions on the case. Yet, the defense does not indicate how defendant's review of hours of raw footage could assist counsel in motion preparation, nor does counsel explain why counsel could not direct the defendant to relevant portions of the discovery materials. There is no reason to believe that defendant has any specialized legal training, which would make his review of all discovery to this point in the investigation necessary in motion preparation. Furthermore, a review by the defendant of the entire discovery package in excess of 1 terabyte of data, discovery laptop or not, could very well delay the defendant's motion response beyond June 26. Ironically, the defense repeats at every opportunity that defendant is being treated differently than other defendants similarly situated. See Def. Letter at 6. See also Exhibit 2, February 21, 2025 minutes page 1213. Claiming defendant is being treated differently than other defendants who would be prosecuted in this court. Yet, that's precisely what the defense seeks, special treatment for defendant, without circumstances that warrant it, and, in the face of understandable and heightened concern for the safety of the people's witnesses that emanates from lackluster control over the discovery and the computers being used to review it. Though the people understand this court's ruling would be advisory in nature, the people ask the court to deny defendant's request for a specialized computer at this time. The people further request that the defense provide adequate notice to the people of any application of the sort they make in federal court, IV. The people's response to defendant's remaining discovery arguments to be clear, the people will provide all discovery to which the defendant is entitled under Article 245. The people continue to review, redact, and disclose materials to the defense on a rolling basis as promised. Nothing about this response should be construed any differently. However, some of defendants' arguments either do not relate to or inaccurately portray the scope of people's discovery obligations. A law enforcement leaks for one, despite fashioning the initial portion of the letter as a discovery update and demand for discovery. The defense devotes much space in its letter to the court outlining what it characterizes as law enforcement's prejudicial statements to the media about the evidence in the case. Certainly, this court cannot be counsel's intended audience. Counsel made similar complaints of pre-trial prejudice in both court appearances. On December 23, 2024, the court responded to counsel's complaints about Mayor Adams' statements, noting that the court has very little control as to what happens outside of this courtroom. See Exhibit 3, December 23, 2024 minutes page 78. Then, on February 21, 2025, counsel raised the issue of pre-trial prejudice in an HBO special. The court responded, "I'm going to cut you off, because that has nothing to do with you moving to have the grand jury minutes inspected for sufficiency. That's definitely going to be an issue in this case, or moving to controvert any of the warrants. You could always supplement your motions, but it's got to start." See Exhibit 2, February 21, 2025 minutes page 1112. Publicity surrounding the case carries no greater relevance to defendant's demand for discovery or his ability to file motions than it did on February 21, 2025. Though defendant continuously invites discussion regarding external statements in the media, the people note that there are only two parties in this criminal prosecution, who each must follow rules regarding pre-trial publicity. The people and the defense. See Rules of Professional Conduct, 22 NYCRR 1200.0, Rule 3.6. The people's limited statements to the media have fully comported with Rule 3.6. The defense, however, has on the one hand cried foul when entities outside the people's control have made public statements or gestures, while on the other has itself fanned the flames of the public attention. Of note, the defense made public statements by setting up a website. That website contains statements made by counsel, both in court and out of court. To the extent defendant's application relates to actions on the part of the district attorney's office, we will continue to conform our behavior to the rules of professional conduct and guard against any prejudicial extrajudicial statements, and controvert any allegations to the contrary. We expect the defense to do the same. B. Federal information or documentation. Finally, defendant demands that the people disclose information and documentation from the federal government received as part of a joint NYPD-FBI investigation. The people will disclose any federally generated information or documentation in our actual possession. However, the people oppose any assertion that the people are statutorily obligated to provide materials within the custody of federal law enforcement agencies. First off, defendant avers that the people have not provided any information or material from federal law enforcement. Defendant's assertion is simply inaccurate. On January 22, 2025, the people served on the defendant certain phone records received pursuant to a notably, the defense ensured that defendant was furnished with a green sweatshirt to wear, consistent with what his sympathizers were calling for supporters to wear at his calendar appearance. In addition, defense counsel addressed reporters outside the courthouse before a group of Mangione supporters, ironically repeating and reinforcing the very acts of law enforcement she claimed to prejudice her client. See Michael Ruiz. Luigi Mangione winks at supporters with green sweater under bulletproof vest. Yahoo News, February 21, 2025, https://www.foxnews.com/us/Luigi Mangione. A murder case raises concerns activist jurors may ignore evidence. Luigi Mangione's lawyer, Karen Friedman Agnifilo addresses press following court hearing. ABC 7 News, YouTube February 21, 2025, https://www.youtube.com/watch V equals IYT 985 PEZ 508. See Luigi Mangione Legal Defense Information, 2025, https www.luigimangoneinfo.com. Search warrant obtained by the people, as well as the FBI analysis of said records provided after an offer of assistance. Additionally, on March 10, 2025, the people provided the Detective DD5S to defendant. A review of the detective reports reveals where, if at all, a given NYPD detective interacted with or was assisted by federal law enforcement, which were few. The fact that defense counsel's review of the discovery overlooked any reference to information provided by federal law enforcement is telling. It is because this was primarily investigated by the NYPD. As a matter of fact, not one of the witnesses who testified before the grand jury was a federal agent or individual with any connection to the FBI. Furthermore, none of the evidence presented to the grand jury was developed by the FBI, seemingly to advance the argument that the people are obligated to provide documentation in the possession of the federal government. The defense cites to People v. Adams, 226 NYS, 3D 533, 537, Sup. CT, Erie Company, 2025. However, defendant neglects to provide its holding. In Adams, the court found that the people are not charged with providing items related to the subject matter of a state case within the federal government's possession, as the people do not have control over federal law enforcement agencies for the purpose of CPL 245, ID, at 538. Instead, the court noted that the people must disclose only the information from federal law enforcement that is in their actual possession, ID, at 539. Therefore, consistent with our obligations, the people will provide discovery related to the subject matter of the case that is in our actual possession. Moreover, the people will make a diligent good faith effort to ascertain the existence of material or information discoverable under CPL 5245.20, where it exists but is not within our control. CPL 245.20, V notes found in clothing for defendant provided by the defense team on February 21, 2025. While defendant continues his unsubstantiated complaints of unfair treatment, the people find it important to make the court aware of how the special treatment to the defendant's benefit was violated when the people made accommodations for defendant's fashion needs during the last court appearance. Whereas most incarcerated defendants must wear jail-issued clothing at their calendar appearances, the people have ensured that this defendant has had the opportunity to change into different clothing when producing him to court. Prior to February 21, 2025 court appearance. Major Mike McKee, a New York State court officer assisting in defendant's transport, was given a bag of clothing for the defendant by members of the defense team. Investigator Sergeant Louis Capillupo was charged with searching the clothing. Among the items of clothing was a new pair of Argyle socks wrapped around cardboard. Secreted in the cardboard were 2 personal heart-shaped notes, one addressed to an unknown person named Joan and the other to Luigi, stating in part, "No, there are thousands of people wishing you luck." In spite of this, the defendant was permitted to wear the Argyle socks, which he first changed into and later changed out of because he felt that they did not look good. Fortunately, the items smuggled were handwritten notes and not contraband capable of harming the transporting officers. Except as otherwise provided, the people asked the court to deny defendants' applications in their entirety. Supreme Court of the State of New York, County of New York. The people of the State of New York preliminary against Discovery Rosa/Olis Luigi Mangione, defendant. Indictment No. IND 75657-24. The following documents have been turned over to defense counsel. Discovery served on the 1st of June 2025 via e-discovery. 21.2 gigabytes in data. 1. CPL section 710.30. 1. B. Notice and Purdue Notice. 2. BWC. Interrogation video. Transcripts for CPL 5710.30. 1. A notice. 41 folders. 275 files, including ABWC and metadata. Altoona PDI. Detwiller. 2 videos. 2. Fox. 1 video. 3. Fry. 2 videos. Ive. Snyder. 4 videos. VBWC transcripts. 11 files. B. Altoona interview room videos. CBWC and metadata. Extradition. 6 videos. I. Taco 2. Pitanza 3. DeMarco Ive. Curcio vs. Brower v. Librizzi. Discovery served on the 1st of July 2025 via e-discovery. 455 GB in data. 3. Supplemental CPL 710.30. 1. B. Notice and Purdue Notice. 4. Additional BWC for CPL section 710.30. 1. A notice. 17 files. 4 videos, including ABWC and dash camera. Pennsylvania State Police. All disclosures were made with the corresponding table of contents delineating file names and or Bates stamps. The table of contents is included in file counts. Updated March 25, 2025. Discovery served on the 1st of August 2025 via e-discovery. 19.9 gigabytes in data. 5. SCI Huntington footage. 63 folders. 179 files, including a surveillance and camcorder footage. Discovery served on the 22nd of January 2025 via hard drive. 735 gigabytes in data. 6. HTAU telephone extraction. Motorola phone at scene. CP1. 5 folders. 9 files. 7. DNA testing raw data. 84 folders. 291 files. 8. NYPD latent print section file. 2 files. 9. Mordecai and Trost detective reports. DD5S. 2 files. 10. Cell tower dump returns and analysis. 9 folders. 655 files. 11. Raw video surveillance footage organized by location. 194 folders. 2,116 files. 112. NYPD police laboratory reports for forensic testing. 1 file. Discovery served on the 21st of February 2025 via hard drive. 105 gigabytes in data. 13. Additional Altoona PD BWC and metadata. 56 folders. 236 files. A. Homan. 2 videos. B. Miller. 1 video. C. Wasa. 2 videos. D. Dedwiller. 5 videos. E. Yeager. 1 video. F. Mazara. 1 video. G. Snyder. 3 videos. H. McCoy. 1 video. I. Fox. 4 videos. J. Fry. 5 videos. K. Hanelli. 1 video. 14. Altoona PD paperwork. 20 files, including but not limited to A. Criminal complaint paperwork, B. Police reports, C. Arrest reports, D. Incident reports, E. Supplemental reports, F. Voucher paperwork, G. Search warrant and affidavit, H. Altoona PD City Docket, I. Confidential information form 1. In an abundance of caution, the people disclosed video surveillance as received from the NYPD, therefore certain video files contained within the disclosure may be duplicative. A handwritten evidence list, K. Patrolman Fry scanned Notepad 1. Post-incident reports, M. Request for subpoenas 15. Altoona PD photos, 174 files, 16. Blair County Sheriff Report, 1 file, 17. Blair County DA Discovery 2 folders, 180 files, 218. Mail sent to Blair County Courthouse, 1 file, 19. PA Department of Corrections paperwork, 8 files, including A. Inmate Cumulative Adjustment Records, B. Inmate Comprehensive Messages Report, C. Inmate Telephone Sheet, D. JPay Records, E. Inmate Assessment Records, F. Monitoring Forms, G. Medical Incident Report, H. Unacceptable Correspondence Form 20. PA State Police Disclosures, 30 files, including but not limited to A. BWC Transport, 7 videos, B. Pennsylvania State Police Report, 1 file, 21. Office of Chief Medical Examiner OCME, Autopsy Disclosures, 8 folders, 261 files, including A. Autopsy Report, B. Autopsy Photographs, C. X-rays, D. Forensic Toxicology Case File 22, OCME DNA Laboratory Case Files and Lab Reports, 6 files, 23. Crime Scene Unit Reports, Photographs and Diagrams, 13 folders, 1,263 files, including the following detective case files: A. 2024-0596, Det. Catlin Walsh, B. 2024-0596A, Det. Edwin McBride, C. 2024-0596B, Det. Sandra Carvajal, D. 2024-0596D, Det. Amy Johnson, E. 2024-0596E, Det. Brian Abuian, 24. Grand jury testimony for non-civilian witnesses and grand jury exhibits, 74 folders, 725 files. 2 certain items are duplicative of what the people received and disclosed from Altoona PD 3. 25. NYPD Police Laboratory Case Files, containing lab reports, underlying testing data, photographs, and expert disclosures, 34 folders, 486 files, including but not limited to A. Photographs of defendant's journal and handwritten notes, B. Ballistic evidence examination/analysis, C. Latent print, DNA, and trace evidence examination/analysis. Discovery served on the 3rd of October 2025 via hard drive, 158 gigabytes in data. 26. ECMS file, containing detective reports, DD5S, and attachments, 64 folders, 2,195 files, including for the following detective case files: A. 2024-0100 hours, Crime Scene Unit, B. 2024-0008, Det. Raymond McCann, Org. Crime ANV, Div C. 2024-0038, Det. Joseph Mitsopoulos, Major Case Squad, D. 2024-0052, Det. Edward Stackpole, Narcotic Borough Man, North E. 2024-0078, Det. Randy Mercado, Gun Violence Suppression, Div F. 2024-0596C, Det. Errol Bagan, Crime Scene Unit G. 2024-0681, Det. Corey Gresco, Warrant Section H, 2024-2696, Det. Christopher Contreras, Latent Print Unit I. 2024-2934, Det. Gregory Green, Dep. Com. Public Info J. 2024-3368, P.O. Mark Mitchell, PBMS Specialized Units K. 2024-3778, Det. Stephen Keys, Real-Time Crime Center 1, 2024-3793, Det. Stephen Keys, Real-Time Crime Center M2024-4230, Det. Kenya Clark, Central INV and Resource Div N 2024-4230A, Det. Keith Gonzalez, Central INV and Resource Divo 2024 to 4877, Redtt, James Curcio, Midtown North Redtt, Squad Page 2024 to 8401, Redtt, Leni Sakins, Real-Time Crime Center Q 2024 to 8715, Redtt, Leni Sakins, Real-Time Crime Center R 2024 to 17795, Redtt, Marcello Gianquito, Real-Time Crime Center 27, NYPD Arrest Paperwork, 8 folders, 229 files, including A. Responding Officer Memo Books, 17 Officers B. Aided Report, 1 file, C. Arrest Report, 1 file, D. Complaint Report, 1 file, E. Scratch Complaint Report, 1 file, F. ARCID, 2 files, G. Property Invoices and Chain of Custody Reports, 204 files, H. Zolper, 1 file, 28, Search Warrants, Orders, and Affidavits, 3 folders, 19 files.
Hi, it's voiceover me. So the rest of the document is just basically a transcript of like what all the police have found, and it's exactly the same as all the stuff that we looked at in the actual document that we were looking at. So if you guys want to read that in your own time, go ahead, but we already know what it is. It was literally in the document we just looked at. That was one of the big documents, and this is the other big document I wasn't able to read in my last video because of time.
Via ECF and email the Honorable Edgardo Ramos, U.S. District Judge, Southern District of New York, 40 Folly Square, New York, New York 10007 Re, United States vs. Mangione, 24 Mag 4375. Dear Judge Ramos, we are in receipt of the government's letter dated April 14th, 2025, in response to Mr. Mangione's motion filed April 11th, 2025. We submit this letter in reply. As an initial matter, the government has not contested any of the facts set out in our motion. Instead, the government makes the following assertions. 1. That the defendant's motion is not ripe, as the case is not yet indicted, and 2. That the defendant cannot dictate the manner in which the government presents evidence to the grand jury. We will address these issues below. The government has not responded to the other 4 points raised in defendant's motion. 1. Ordering the Attorney General to certify that she read Local Rule 23.1. 2. Restraining the Attorney General from making extrajudicial statements in violation of Rule 23.1. 3. Ordering the government to produce for in-camera inspection any documents from the SDNYs and the Attorney General's consideration of the death penalty, and 4. Ordering the government to produce documents of communications between the government and anyone advocating for any particular sentence by or on behalf of any business, corporate interest, lobbying or other party, directly or indirectly. 1. The district court's supervisory authority over the grand jury allows it to remedy clear, substantial, undisputed violations of due process occurring before the grand jury in a capital case. On these facts, the government argues that the court should not take action, not because the government offers facts contrary to those advanced by the defense, but because the matter is not ripe for adjudication as it is a grand jury matter. However, this court retains what the Supreme Court has called a supervisory authority over the administration of justice. See McNabb v. United States, 318 U.S. 332, 341, 1943, Arfit v. United States, 348 U.S. 11, 1954, Bank of Nova Scotia v. United States, 487 U.S. 250, 253, 1988. This supervisory authority is not limited to the inside of a federal courtroom. Rather, it extends to eliminating prejudicial extrajudicial statements that may affect the grand juries who sit in this district and whose indictments will be heard by this court. Local Rule 23.1b. Accordingly, this court need not wait until an indictment is returned and a notice of intent to seek the death penalty is filed. The United States Attorney General has made a very public and prejudicial directive that death be sought. Moreover, because the Attorney General has violated Rule 23.1 and has prejudiced this grand jury process, this matter is ripe right now. Once a prejudiced grand jury returns a death-eligible indictment, it is simply too late. A. The supervisory authority of federal courts. There is Supreme Court precedent for federal courts intervening in cases as part of what has been described as their inherent supervisory authority. See McNabb v. United States, 318 U.S. 332, 341, 1943. Judicial supervision of the administration of criminal justice in the federal courts implies the duty of establishing and maintaining civilized standards of procedure and evidence. Arford v. United States, 348 U.S. 11, 1954. Bank of Nova Scotia versus United States, 487 U.S. 250, 253, 1988. In the exercise of its supervisory authority, a federal court may within limits formulate procedural rules not specifically required by the Constitution or Congress. The supervisory authority doctrine is particularly appropriate for situations where a decision is based on bias or lack of process, as is the Attorney General's directive here, and where no other law or rule would apply to curtail it. See Arford, 348 U.S. 11. The Arford decision offers a useful analogy to the present case, as it stands broadly for the proposition that the federal courts should always be alert for decisions impacting life and liberty that are not free from bias and lack of due process. There, the Supreme Court reviewed a decision of the District Court, which held a defense lawyer in contempt during a criminal trial. The government's position in Arford was that because the trial judge has broad leeway and discretion in making contempt findings, that the decision was beyond the review of other courts. As the court noted, the government has vigorously pressed upon us the leeway that must be allowed to a trial judge in assessing the necessities of such a situation. ID, at 14. Even though the court could point to no rule, law or precedent curtailing the trial court's decision to hold the lawyer in contempt, the court availed itself of its supervisory authority over the administration of criminal justice to set aside the trial judge's decision. In reaching its decision, the Supreme Court stated, "Our concern is with the fair administration of justice and that the record is persuasive that instead of representing the impersonal authority of law, the trial judge permitted himself to become personally embroiled with the petitioner." ID, at 15. Justice Frankfurter's opinion in Arford is useful to the present case. First, the court was confronted with a situation where the trial judge was motivated by personal bias or animosity against the defense lawyer, which is why it observed that the trial judge permitted himself to become personally embroiled with the lawyer. Second, there was no suggestion that the trial court violated a law or rule in holding the petitioner in contempt. Rather, it was a pure matter of discretion. Third, the court observed that even in the absence of the trial judge violating a law or rule, the fair administration of justice called for the court's intervention as part of its inherent supervisory authority. We are asking this court to do here what Justice Frankfurter said was not only appropriate, but required to preserve the fair administration of justice. ID. It bears repeating that not only has the Attorney General abrogated the death penalty protocol completely, she has done so in uncontested violation of Local Rule 23.1, which applies explicitly to grand jury proceedings, and in a manner that is dangerously prejudicial to this defendant facing a capital indictment. The inherent supervisory authority of this court, recognized repeatedly by the Supreme Court of the United States, is at its pinnacle at this very moment. Be the court's role concerning the federal grand jury when it comes to our grand juries. Our local rules use the precise language Justice Frankfurter used in his Arford opinion. The administration of justice Local Rule 23.1 b states, W. With respect to a grand jury investigation, a lawyer associated with the investigation shall refrain from making any extrajudicial statement if there is a substantial likelihood that it will prejudice the administration of justice. The local rules are overseen and administered by this court. It is the explicit province of this court to ensure that the grand juries of this district are not prejudiced by extrajudicial statements. At a minimum, the application of Local Rule 23.1 to grand juries means that this court has the authority to supervise the conduct of grand juries, at least to that extent. Local Rule 23.1 exists as part of this court's more general supervisory authority to ensure that the fair administration of justice exists both in the courts and the grand juries. Of course, the particulars of how evidence is presented is the province of the prosecutor. On this point, the government stated that the defense should not be able to dictate, through the authority of the court, the manner in which the government presents evidence to the grand jury. The defense agrees with this statement. But this is not what we are trying to do. We have no interest in the manner in which evidence is presented to the grand jury. We do not seek to control what witnesses or documents are presented to the grand jury, or dictate what may be said in the grand jury, or even be provided with transcripts of what is presented. Rather, we seek the court's intervention only to prevent seating a grand jury whose members have been infected with the Attorney General's improper comments. There is no serious question that the Attorney General violated Local Rule 23.1. It is so obvious that the government did not even attempt to mount a response to our initial motion. To summarize, the Attorney General, a lawyer associated with the investigation, made extrajudicial statement, S, that provide ample basis to believe would prejudice the administration of justice since she spoke publicly about I, her past history as a capital crimes prosecutor, 2, that if there was ever a death penalty case, this is 1, and 3, that she herself has been threatened because of this case, 5, that a reason for seeking the death penalty is that the victim was a CEO, 5, that Mangione is guilty, and v. that Mangione committed 2 statutory aggravating factors and should be executed. Note 2. That the Attorney General, in all of her statements, never mentioned the small matter of the presumption of innocence or even that Luigi Mangione has yet to be indicted on federal charges. These statements would be damaging in any case. However, in a death penalty case, it is critical that the court exercise its inherent authority to ensure Mr. Mangone's rights are protected because, as the Supreme Court has repeatedly emphasized, the death penalty is categorically distinct from other situations and requires heightened protections. See, for example, Lockett v. Ohio, 438 U.S. 586. 605, 1978, the need for treating each defendant in a capital case with that degree of respect due the uniqueness of the individual is far more important than in non-capital cases. Gregg v. Georgia, 428 U.S. 153, 189, 1976, W. Here discretion is afforded a sentencing body on a matter so grave as the determination of whether a human life should be taken or spared, that discretion must be suitably directed and limited so as to minimize the risk of wholly arbitrary and capricious action. 2. Requested relief in our April 11, 2025, motion. Counsel requested 6 forms of relief. I. Preclude the government from seeking the death penalty. 2. Order that any proposed federal grand jurors be screened for exposure to the Attorney General's prejudicial public statements. 3. Order the Attorney General to certify she has read Local Rule 23.1. 5. Restrain the Attorney General from extrajudicial statements in violation of the rule that could prejudice Mr. Mangone's right to a fair hearing by a grand jury, including the grand jury's consideration of death-eligible offences and factors. V. Order the government to produce for in-camera inspection any memoranda, documents and notes from the SDNY's consideration of the death penalty, as well as any memoranda, documents, and notes provided to the Attorney General as part of her careful consideration of the evidence, and v. Order the government to produce to Mr. Mangione any emails, records, documents, memoranda and notes of any communication between a government official and anyone advocating for the death sentence, or any particular sentence, in this case by or on behalf of any business, corporate interest, lobbyist or other party, directly or indirectly. The government failed to challenge requests 3v in their response and has therefore conceded these points. We ask that this court enter an order granting 3v as to requests I and 2. Counsel has noted above why this issue is ripe and why the court has supervisory authority to grant the requested relief. This matter is also gravely pressing given that the deadlines under Rule 5.1 of the Federal Rules of Criminal Procedure and 18 U.S.C. Section 3161, b, for the government to indict or conduct a preliminary hearing expire this Friday, April 18, 2025. Without this court's intervention, the government will continue to violate Mr. Mangone's due process rights as they seek the death penalty.
So those were the 2 really big documents I wasn't able to cover because of time in my last video on Luigi Mangione. So now we are going to move on to the more relevant updates of the case. A lot of these updates are from Reddit because again, I do live in Australia. So a lot of these documents I don't officially have access to because when I click on the link, it gives that very lovely page on the internet when you're Googling stuff saying, you don't have access to this page. So a lot of these are from Reddit, so please take it with a little bit of skepticism, but a lot of these do actually look legit, and I do find it very useful because, again, I can't officially look at the documents on my side of the world. So this is a alleged interview with a roommate that Luigi had in the actual hostel he was staying in New York. Take it with a little bit of skepticism because I did find this on Reddit, and this is mostly just for archive reasons, because when I was reading it, some people were saying people don't really remember it or it's like anything noticeable, but again, I'm just doing it for archive reasons. So I did read the actual official article with the alleged interview with his alleged roommate in the hostel in New York. There's only like 2 things actually worth noting. I thought there'll be a lot more interesting things to bring up or anything like that, but there's nothing really interesting. And like the only 2 things that are like, I guess, worth mentioning in the actual article itself is, the first one is the reason why Luigi Mangione was wearing a face mask at the time is because apparently he was coming down with a cough. And another one is apparently Luigi Mangione was sleeping on the top bunk and he had a Korean man sleeping underneath the bottom bunk, and apparently he moved a lot when he was sleeping. I don't think that's anything worth noting. A lot of people move around a lot when they sleep, so, and those hostel beds are not comfortable whatsoever, so those are probably like the 2 things worth noticing. All of that is alleged. This is just for archive reasons. So now we are moving on to like more relevant information that's more updated, and a lot of these documents are like more like in the same time period came out. So this is, and a lot of these documents did come from Reddit because I do live in Australia, so a lot of these documents I don't actually have access to, so take a lot of these documents with a little bit of grain of salt, but a lot of these documents are official. They're just very useful for me when I do this kind of stuff. The 21st of April 2025, this is Hi, it's voiceover me. So some of these dates I literally got from Reddit, like when they were posted, so please correct me if there's any dates I got wrong. I'm literally going off by the dates I saw posted on Reddit with some of these documents, so sorry about that if I got them wrong. The court ordering a response from the government. I'm not going to read you the whole thing because we've already seen it before in my last video. I'm just going to show you guys the bit that's like most relevant. I'll pull up on screen here for you guys.
The 17th of April 2025 to the 16th of April 2025. Bernard, Jackie Atherton. Order scheduling hearing to submit a response. Blair County District Attorney's Office, the 21st of April 2025. E-service served. Dickey, Thomas M. the 21st of April 2025. E-service served.
Luigi Mangione's federal court case. Luigi Mangione pleaded not guilty. So this is on the 25th of April 2025. This is the transcript of that actual case on Karen's side. Again, because of legal reasons, they can't show us both sides of the actual transcript, but the actual full transcript document is available. That is, again, on my website for this week's episode if you guys want to read that, and it's basically exactly the same as what I'm going to show you guys, so I'll put it up on screen for you guys. So this is from Karen Agnifilo. Hi, it's voice of me. So I mentioned this briefly at the beginning, but in the actual courtroom itself, cameras were not allowed, so the only photo evidence we have is from the courtroom sketch artists. I just thought I should put that here instead of not giving any context, because I feel like I need to put it in here. Later on, we will go into the document of someone who was a witness in the actual courtroom when it was all happening. It is a very interesting read, and we'll get to that later on in the video.
The court. Good afternoon. Everyone can be seated. Before we begin, I just want to make a record about my prior employment and my knowledge of the lawyers in this case. From July of 2005 to October of 2017, I was an assistant United States attorney in the United States Attorney's Office for the Southern District of New York. I returned to the office in November 2021, as a Deputy United States Attorney and remained in that role until May of 2023. During that time, I was the ultimate supervisor of every case in the criminal and civil divisions of the U.S. Attorney's Office. From May of 2023 to December of 2023, I was special counsel to the U.S. Attorney, and in that capacity supervised all cases in the criminal division and certain cases in the civil division. During the time I was Deputy U.S. Attorney, I participated in the interview process that resulted in Ms. Messiter's hiring as an Assistant United States Attorney, and other than that, I am only generally acquainted with these four authors, and I never worked with any of them directly on any particular case or matter. I also know Ms. Friedman Agnifilo as a law enforcement partner on various issues and matters when she was at the Manhattan District Attorney's Office, and I was variously at the U.S. Attorney's Office and then Chief of the Criminal Division at the New York Attorney General's Office, and also when I was Commissioner of the New York City Department of Investigation from 2018 to 2021. We don't have a personal relationship beyond our past professional work together. I also know Mr. Moskowitz very well, both as a former adversary in criminal cases and as a professional colleague in the criminal bar of this court. I don't believe that I know Mr. Agnifilo or Mr. Kaplan. I have rules specifically regarding my recusal from U.S. Attorney's Office's matters which are posted on my public website. Mr. Gentile, have you reviewed those rules and have you reviewed the files at the U.S. Attorney's Office related to this matter? Mr. Gentile, we have, Your Honor, the court, and to the best of your knowledge, are you aware of any reason why I should recuse from this matter? Mr. Gentile, we are not aware of any reason, Your Honor. The court, Ms. Friedman Agnifilo, let me turn to you. Are you aware of any reason why I should recuse from this matter? Ms. Friedman Agnifilo, no, Your Honor. The court, okay. Based on my own knowledge of the case and the representations of the government, I also don't see any basis for recusal. But Ms. Friedman Agnifilo, if you'd like time to consult with your client, just send me a letter within 7 days of today if you change your mind or if you have any issue you'd like to raise. Obviously, should facts develop as the case proceeds that bear on anything related to recusal, anyone should feel free to bring that to my attention. Proceeding continues. The court, Ms. Friedman Agnifilo, if in the future you see any reason to make a renewed bail application, just send that directly to me, and I have rules on my public website about how that should be presented. Ms. Friedman Agnifilo, thank you, Judge. Proceeding continues. The court, okay. Let me just ask you briefly, Ms. Friedman Agnifilo, whether at this point, again, I'm not going to hold you to it, but just as we're thinking about the schedule, whether at this stage the defense has a sense of any expert testimony needed at the guilt phase for a defense case. Ms. Friedman Agnifilo, we're not prepared to address that issue at this time, Your Honor. The court, okay. All right, we'll return to that at an appropriate time. Proceeding continues. The court, Mr. Gentile, what can you tell me about your coordination with the District Attorney's Office regarding a trial of this matter or anything else that relates to our order of proceeding? Mr. Gentile, Your Honor, the District Attorney's Office, I believe they have a trial already set for the fall. I believe that they will be proceeding on their normal course. We respectfully submit that we would proceed in our normal course. Given this is a capital case and there are issues that need to be litigated beforehand, we would expect just the nature of the two cases and the nature of the scheduling, that the Manhattan District Attorney's Office will most likely conduct their trial first, but we would not ask the court to make any special accommodations. We just ask the court to proceed during the normal course. The court, Ms. Friedman Agnifilo, what is the date set in the state for Mr. Mangione's state trial? Ms. Friedman Agnifilo, Your Honor, we haven't discussed a trial date in the state yet with Judge Caro. What we've been talking about is potentially having hearings in the fall, suppression hearings, for example, but we have not talked about that. We understand that there was a handshake deal between the prior administration and the Manhattan DA's office that their case would go first. But now that the death penalty is being sought here, we are going to make a request that that no longer be the case and that this case proceed, Your Honor, and not the state court case. So that's going to be our official position. We plan on writing on that and making more official requests, but we just wanted to let Your Honor know that that's what our position is. The court, that's very helpful. Thank you. I mean, I think I agree with Mr. Gentile that we will, barring some request otherwise. My intention is that we will set a schedule for this case as if it's the only case. And should an issue arise involving a conflict between the scheduling that either party wants to bring to my attention, you can certainly do that. But I think in terms of our management of this case, we ought to proceed as if it's the only case until circumstances suggest otherwise. Ms. Friedman Agnifilo, yes, it's partly scheduling, Your Honor. As you know, there's a lengthy mitigation process that's going to occur in this particular case. It's partly scheduling, but it's also constitutional issues are going to be impacted if we are forced to try that case first and then before Your Honor. But we plan on briefing that for Your Honor, but I just wanted to let Your Honor know that that's coming down the pike. The court, okay. And so the next scheduling issue that I think we should address is I know that the defense filed a motion before Judge Parker on the 11th of April related to the death penalty issues in this case. Of course events have overtaken us in terms of what the posture of that motion was. What I would propose is that now that Mr. Mangione has been indicted and the government has filed its notice of intent as of last evening, it seems to me that the best course is either to deem the prior motion withdrawn without prejudice, or if the defense prefers, I can deny the motion as moot without prejudice to renewing those arguments and set a schedule that allows you to brief in a single motion all the issues that you want to raise regarding any actions of the government prior to indictment and any issues raised by the notice of intent. Ms. Friedman Agnifilo, if Your Honor is referring to the motion that we filed before Judge Ramos, the Part 1 judge, the court, right. I think it initially went to Judge Parker, then it got sent to Judge Ramos in his capacity as Part 1 judge. We're talking about the same motion. Ms. Friedman Agnifilo, yes, Your Honor. We would request an opportunity to renew that, set a motion schedule and renew that because we're obviously in a different procedural posture. The court, yes. So I think in terms of just the docket, I'll reflect that the motion's been denied as moot without prejudice. And how much time, Ms. Friedman Agnifilo, are you requesting to file a unified motion that might renew whatever arguments from the prior one you want to renew, as well as anything raised by the notice of intent? Ms. Friedman Agnifilo, if we could have. Excuse me 1 second. Counsel and defendant conferred. MS. Friedman Agnifilo, Mr. Agnifilo is about to start another trial, Your Honor. The court. Sure. Take a minute to confer. Counsel and defendant conferred. MS. Friedman Agnifilo, if we may have until the end of June, we'd appreciate that. The court. Sure. That is consistent with what I had in mind, approximately 60 days. Why don't we say Friday, the 27th of June? Proceeding continues. The court. Okay. All right. So I'll set the government's date to respond for Friday, the 8th of August, and the 22nd of August for a reply. And as I just said, I'd also like to, while we're here and have a schedule for discovery, set a schedule for the sort of ordinary pre-trial motions in a criminal case, any motions to dismiss counts of the indictment, as well as any suppression motions. And so bearing in mind that these things are going to be proceeding somewhat on 2 tracks, I would propose to the defense sometime in late July or August for those motions. I see Mr. Moskowitz is maybe not happy with that, assuming that you have received all of the discovery by the end of May, as I've directed the government to provide if that's at all possible. How much time do you presently think that you all would like to review that discovery and consider what pre-trial motions you might have? Counsel and defendant conferred. MS. Friedman Agnifilo, if it's okay with Your Honor, if we could have until the end of September, since there's approximately 3 terabytes worth of data that is going to be produced. We're just getting started going through all of that. We'd appreciate that time. The court. I think that that's reasonable given the volume of the discovery and the other issues in this case. I'll set the 26th of September for now, Friday, the 26th of September, as a date by which the defense will make any motions against the indictment or related to suppression. And the government's response on the 31st of October, reply the 14th of November. Okay. I'd like to set then a next conference date which will address the pre-trial motions. Set a hearing date if we need to for suppression. Why don't we set that for Friday, the 5th of December at 11 a.m. My goal will be to set a trial date at that conference. So all counsel should come prepared on the 5th of December with their calendars, with any expected requests that you might have, if necessary at that time, Ms. Agnifilo, regarding any additional time you feel you need for mitigation investigation. But my goal will be to leave that the 5th of December conference with a firm trial date set for 2026. Okay. And of course if anyone thinks there's a need for a conference before then because of issues related to the state case, because of issues that arise in this case, just don't hesitate to reach out, to send me a letter or reach out directly to Ms. Vernius to request a conference, and we'll set that at a mutually convenient time. And likewise, the September, the fall dates for the motion practice are only outside dates. Sometimes it will happen that early resolution of a particular issue would be helpful to counsel, so if you want to file something before then, don't feel you have to wait, but we'll expect those motions in the fall. Okay. The last thing before we turn to the speedy trial clock and any other issues that counsel might like to raise is that given the nature of this case, I would like to just remind all counsel of the strictures of Local Criminal Rule 23.1 about public commentary about this matter that could impede or affect Mr. Mangione's ability to get a fair trial and the court's ability to select a fair jury in this case. I'm specifically directing the government to convey my directive to Mr. Clayton and request that he convey the same to Attorney General Bondi and any of her subordinates at Main Justice. Ms. Friedman Agnifilo, anything else you'd like to raise before we talk about the speedy trial clock? Ms. Friedman Agnifilo, I do want to make one record, if that's okay with you, Your Honor, regarding this unprecedented dual prosecution, simultaneous dual prosecution of Mr. Mangione for the exact same offense. It's created numerous logistical and constitutional issues for us that, as I said, we'll be addressing in future motions to you, but there is one thing I'd like to put on the record. We were just informed by the state court prosecutors that they were eavesdropping on all of Mr. Mangione's calls. They were listening to his attorney calls and his other calls that are going on, and they said that it was inadvertent that they listened to a call between Mr. Mangione and me, who I am the lead counsel of record, and they know that, and obviously the United States knows that as well. And they said that these calls were given to them by the Southern District and they're being recorded at MDC, so we just want to make sure that something is put in place, Your Honor, that does not. They said that they didn't, that only one person listened to it. They took steps to minimize any encroachment into the attorney-client relationship, and no one discussed with the one person who did listen, and that it was inadvertent. But we would just ask that the Southern District put something in place to ensure that no calls to his legal team and among the legal team are either recorded or listened to. Certainly not provided to the Manhattan DA's office or the U.S. Attorney's office. The court, Mr. Gentile, what can you tell me about this situation? Mr. Gentile, Your Honor, this is the very first we've heard of this situation. Of course that's not the normal practice for the U.S. Attorney's office or any office. All jail calls are recorded, as the court knows, but we do not pull attorney-client calls. We will look into it, and we will make sure we rectify it, Your Honor. The court, okay. I mean, recognizing that you've just heard of this situation, I'd like a letter from the government within 7 days of today, Friday, the 2nd of May, I believe. Just updating the court on, first, that Mr. Mangione is being afforded appropriate access to a line that is reserved for attorney calls. My understanding is the MDC still has such a line. Is that correct, Mr. Gentile? I can't answer that, Your Honor. The court, so I would like to know what are the arrangements for Mr. Mangione to be able to speak to his attorneys without. I know those calls are typically recorded by the Bureau of Prisons, but to ensure that he has access to a line that is segregated from any calls that go to the government, and to the extent there has been inadvertent production, what the U.S. Attorney's Office is doing to ensure that those calls have been segregated and aren't accessible to any member of the prosecution team. Mr. Gentile, certainly, Judge. The court, okay. Mr. Gentile, anything else the government would like to raise before we talk about the speedy trial clock? Ms. Friedman Agnifilo, no, Your Honor. Mr. Gentile, no, Your Honor. Just briefly, with respect to Rule 16 discovery, we anticipate producing that discovery pursuant to a protective order. We conferred briefly with defense counsel prior to Your Honor taking the bench. We will meet and confer about the terms of that protective order, but we just wanted to let the court know that a protective order will be forthcoming. The court, okay. And obviously if you reach an impasse on the terms of that and you need my involvement, just let me know and we can arrange a conference if necessary. Mr. Gentile, certainly, Judge. With respect to the Speedy Trial Act, the government moves to exclude the time between now and the 5th of December of 2025 from the provisions of the Speedy Trial Act to allow the government time to produce discovery, allow defense counsel time to review that discovery, and make whatever motions it deems appropriate. MS. Friedman Agnifilo, we agree, Your Honor. The court, okay. I'll just note that the indictment was returned on the 17th of April, recognizing the government's position that time doesn't begin to run until arraignment. I'm not sure that I agree with that position as a legal matter, but in any event, at most 7 days have elapsed on the speedy trial clock. However, I will exclude the time from today until the 5th of December of 2025. I find that the ends of justice served by excluding that time outweigh the interests of the public and the defendant in a speedy trial, because the time is needed for the government to complete its production of discovery, for the defendant and its lawyers to review that discovery, for the filing of motions specifically related to the seeking of capital punishment, as well as motions related to the indictment and any Fourth Amendment or Fifth Amendment suppression issues, and, in addition, for all counsel to continue to discuss the appropriate schedule and progress of this case. Okay. Anything further, Mr. Gentile? Mr. Gentile? Not from the government, Judge. Thank you. The court, Ms. Friedman Agnifilo. MS. Friedman Agnifilo. No, Your Honor. Thank you very much. The court, okay. The defendant will remain in custody, and I will see you all on the 5th of December. We're adjourned. Adjourned.
So that's what the full transcript says, and there is another massive document I'm not going to be going over. It is like 27 pages long. That will be its own video. I wasn't really intending for the first 5 videos on this YouTube channel strictly just to be Luigi Mangione. I was planning like other things like in between, but there's just been so much going on in like such a short amount of time I want to cover and keep up to date for you guys. This is like a couple of notes I have of like my own personal opinion after reading that transcript that I kind of found funny or I want to add here. So this is my own personal opinion. When I was reading this document, I found it quite nice. The judge was a lot more nicer and a lot more willing to let Karen see her client Luigi compared to the last time when we were looking at the other documents. This judge, he was very much, yes, you can go talk to him. If you want some more time to talk to your client Luigi about it, just send me a letter and I'll grant it. And I found that a lot more nicer compared to the last judge was like, no, you can't. Oh, you have time now. You can do it now in front of all of us, compared to this judge. I just found that like really nice, really sweet, and I realized that going through the actual document, that wasn't just at the beginning. It was like all through the document. The judge was a lot more lenient, saying, yeah, you can. You just write me a letter. It'll be fine. This is another bit I found quite interesting. I think everyone knows about this by now. They want to move the actual death penalty case first. They want to do that one first compared to the Pennsylvania charges, because the reason why they want to do that is because a lot of things that are happening in the federal charges against Luigi Mangione will affect the charges he has in Pennsylvania. When I was reading this document, they haven't really officially agreed on what time they want to actually do it or when. So again, I found that quite interesting. So this bit I found quite interesting. So with the actual like death penalty, it hasn't been actually finalized. It's been through a couple of different people, but it actually hasn't been officially finalized. Again, all talk, no show. So they haven't really like officially finalized the dates for that to have that like officially done. So the judge judge said he will request a response from the government on August 8th and August 22nd. He said we'll wait and see what they will reply with. Also, another thing I want to add here, so Karen requested they would have everything looked at from all the evidence that I'm assuming they all just received now as reading this document. They would have it all looked at the end of September, so around 26th and the 25th of September, because there is about 3 gigabytes of footage that they need to look over, find quite nice. The judge did say, hey, if you guys need more time or if you want a conference to discuss anything about the case, because it is a very big case with a lot of different things going on, the judge did say, just send me a letter and they'll make that happen. So I find that quite nice. Again, I think I saw earlier when I was doing this document, there is going to be a conference happening soon for Luigi Mangione, but we will get to that point later on in the video because of dates and time and order. So this bit I found quite interesting and like kind of funny. Here is, I think everyone knows about this too, is Karen brought up people were listening to Luigi Mangione's phone calls with him and his lawyers, and by law, they're not meant to be listened to. They're breaking the law when they're listening into basically a lawyer and their client's phone calls. If it's a personal phone call, they're allowed to listen to it. But I found that very amusing and Karen brought it up, and then the judge asked the actual prosecutor saying, hey, did you guys know this? Why are you listening to his phone calls? And they said, no, we don't know anything about that. It was very funny. It's very sheepish. So basically, someone noticed Luigi Mangione was on a phone call and they started listening in, and then there was, oh, I'm not allowed to listen to this. Then they kept on listening to the actual phone call he had with his lawyer. Now, they're not meant to do that. Whoever did that we'll find out later, they fucked up so hard. The funny thing about it is, prosecutor side, they were like going, no, we don't know anything about this. What are you on about? It was funny to read. So basically Karen brought up saying, hey, can we please have things put in place so this does not happen again, so people won't listen into Luigi Mangione's phone calls with his legal team. So things have been put in place for that. And we will get into later on about the actual response about listening into the phone call and who did it. So also discussed in the document, when Luigi Mangione will have his really big court case, that will happen around December 5th. But we'll see what happens in the next couple of months if that changes or anything like that. Again, this is currently when we're reading the document. So those are some of my thoughts of when I was reading the actual transcript and everything that was going on with Luigi Mangione's federal hearing. This is another document update.
Page 1, USDC SDNY document electronically filed doc, date filed, the 25th of April 2025. United States District Court, Southern District of New York, United States of America, v. Luigi Nicholas Mangione, Defendant, S. 25 CR 00176, MMG, Order, Margaret M. Garnett, United States District Judge. This order is entered, pursuant to Federal Rule of Criminal Procedure 5, F, and the Due Process Protections Act, Pub. L. Number 116 182, 134 Stat 894, October 21, 2020, to confirm the government's disclosure obligations under Brady v. Maryland, 373 U.S. 83, 1963, and its progeny, and to summarize the possible consequences of violating those obligations. The government must disclose to the defense all information favorable to an accused that is material either to guilt or to punishment, and that is known to the government. ID, at 87. This obligation applies regardless of whether the defendant requests this information or whether the information would itself constitute admissible evidence. The government shall disclose such information to the defense promptly after its existence becomes known to the government, so that the defense may make effective use of the information in the preparation of its case. As part of these obligations, the government must disclose any information that can be used to impeach the trial testimony of a government witness within the meaning of Giglio v. United States, 405 U.S. 150, 1972, and its progeny. Such information must be disclosed sufficiently. Page 2. Advance of trial in order for the defendant to make effective use of it at trial or at such other time as the court may order. The foregoing obligations are continuing ones and apply to materials that become known to the government in the future. These obligations also apply to information that is otherwise subject to disclosure regardless of whether the government credits it. In the event the government believes that a disclosure under this order would compromise witness safety, victim rights, national security, a sensitive law enforcement technique, or any other substantial government interest, it may apply to the court for a modification of its obligations, which may include in-camera review or withholding, or subjecting to a protective order all or part of the information otherwise subject to disclosure. For purposes of this order, the government has an affirmative obligation to seek all information subject to disclosure under this order from all current or former federal, state, and local prosecutors, law enforcement officers, and other officers who have participated in the prosecution or investigation that led to the prosecution of the offence or offences with which the defendant is charged. If the government fails to comply with this order, the court, in addition to ordering production of the information, may specify the terms and conditions of such production, grant a continuance, impose evidentiary sanctions, 4. Impose courtes or other solistans or tile these sports disciples of this order does not purport to set forth an exhaustive list of the government's disclosure obligation. 2. The Classified Information Procedures Act sets forth separate procedures to be followed in the event that the government believes matters relating to classified information may arise in connection with the prosecution. See 18 U.S.C. App 31 et sec. Page 3. Dismiss charges before trial or vacate a conviction after trial or a guilty plea, or enter any other order that is just under the circumstances so ordered. Dated April 25, 2025, New York.
The 26th of April 2025. This is the Commonwealth replying to Thomas Dickey's response.
1. The 25th of April 2025 Commonwealth's answer to the defendant's omnibus pre-trial motions. Blair County District Attorney's Office. The 25th of April 2025 E-Service. Dickey, Thomas M. The 25th of April 2025 E-Service. Served Commonwealth of Pennsylvania.
The 29th of April 2025. Now, this is a actual document. Someone posted it on Reddit saying they were actually in the actual courtroom when Luigi Mangione was having his hearing. Now, I did read the actual document itself. I do have some notes on it that I found quite interesting that I want to bring up later on. And also, one thing I do really want to add here, please do not come after anyone in this video that I've mentioned, especially this person here who says they were in the actual courtroom itself and they were able to see and witness Luigi and everything going on in the room. They did do the best they can to give us all the information that they can, and also, and please do not harass them for like any more information. They do have a normal everyday job and I don't want them to lose it, so do not come after this person whatsoever. It was very lovely of them to write this little thing for us so we can go read it and get at least a little bit of a taste of what was actually happening in the actual courtroom itself instead of directly from reporters and stuff. Again, from Reddit, I'll put their little username up on the side. This is fully from them saying what they saw and witnessed in the actual courtroom and how Luigi Mangione is. So, this is what the full document actually says.
Page 1. Luigi Mangione Federal Court Hearing Disclaimer. I'm apprehensive about posting this. Be nice, please. I was very grateful for this experience. Please don't dismiss me as just a fangirl. I'm a former criminal justice student. I've always been interested in true crime and keep up with many cases like the Idaho 4, Menendez Bros, Diddy, etc. I also work a job that would get me taken off the jury pool fast. I have many reasons for supporting LM and his right to a fair trial, not just because of his looks. Those are my credentials. Now let's get down to it. Also, there might be stuff that I missed, so I'll answer any questions. Court experience. Federal court is a lot nicer, accommodating, and organized. Most people there seem to be pro-LM or indifferent. Officers were overheard having a conversation about how nice it must be for him to get some fresh air and stretch his legs. This is a stark difference from the last hearing at state court. Those officers hated him and everyone that showed up to support him. It's true they screamed he's a criminal at us, while they were aggressively pushing and yelling at us to get out. If you decide to show up to the courtrooms, federal court is where you would want to see him, at least at Thurgood Marshall Court. Can't speak for 500 Pearl. Officers were better organized with crowd control and kept the public informed of what would be happening. They ensured no chaos broke out and walked people in 10 at a time in a single file line. They placed certain measures like a U.S. Marshal watching the camping line so no one caused trouble. Cough cough, smelly MAGA man and his friends. There were canine dogs sniffing around, so keep that in mind because someone had their backpack confiscated and searched. They let in about 20-30 people from the public, maybe more. State court let in 15-16 people, and you didn't know you were going to make it in until 10 minutes before the hearing started. For federal, the people who made it in knew they were getting in at 10:30 a.m. and the hearing started at 1 p.m. Public was let in first, then journalists, opposite for state court. However, a bench of supporters were kicked out to make room for more journalists, so the number was 20-30 after kicking out that bench. Everyone else online who didn't make it to the courtroom was brought upstairs to an overflow room. People in the overflow room would watch the hearing on a live stream they set up. So even if you didn't get into the room, your efforts were not wasted. State court at the last hearing had no overflow room or live stream set up despite bringing up over 100 people into those small hallways. I spoke with a girl who was in the overflow room, and she said their view was from the POV of the judge and the camera was focused on the defense team. They could see the front of LM's face, so I hope one of them can detail their experiences. Those of us in the courtroom had obstructed views, no matter where you sat. The room could probably fit 100 people, but most of the booths are for the press. If there were 10 booths that hold 10 people each, then 3 out of 10 booths were for the public. The public was sat in the back booths while the press took up the front. Sketch artists were in the jury box, and there were about 3 different sketch artists with a clear view of him. This would not stop them from butchering his appearance. They really need to find. Page 2. Their passion in life. BC. It is not sketching. Those of us in the room could see the back of his head and his side profile. Something I found interesting was at the last hearing in state court, the judge was already in the room and LM was the last person to enter. He entered through the back and walked down the aisle and took his seat. For federal, LM entered before the judge, which is why people were caught off guard. The judge was the last one to enter, and everyone had to stand for the judge, including LM. They didn't have to do this for state court. When he stood up, the view was clear and unobstructed. When everyone was told to be seated, there was a delay with him taking a seat. I noticed that he kind of lingered for a little and then sat down. Maybe he wanted people to get a view of him. Who knows? Physical appearance: tan prison jumpsuit with white long sleeve under. The same one he was pap leaving with after the February hearing. Tan washes him out, but he can pull off anything TBH. He was not shackled or wearing a bulletproof vest. Those goon guards weren't even lingering over him. He had one guard with him, and that guy was sitting to the side in a chair watching him. So this shows you that they only create a circus when the cameras are rolling. He is not a threat or as dangerous as they make him out to be when the cameras are rolling. I'm pretty sure he walked in without a huge entourage of police escorting him. I don't remember him being restrained and he took his seat by himself. Hair was short, but not buzzed. It wasn't a fresh cut, but it looked recently cut and grown in a little. He had some facial hair, but it wasn't a beard, more like some light scruff. In about a week or so he would look like the blue Bali shirt photo. He looked eerily younger in person, which made me sad. In my opinion, he looked nothing like the other court pictures that came out where he looks mature. He looked like his younger photos pre-arrest, even during the arrest. I can only speak for his side profile, but some examples of what he looked like to me. Polaroid picture of him with 2 friends, and he's wearing bright orange looking up, and to the side him in that pink shirt at a party looking to the side. He was wearing shorts and the white Adidas shoes. Most accurate, that picture of him playing pool with his long ass toes out. Please don't roast or make fun of him for this. I'm just stating what I observed. I'm not sure if he's balding from the back. There was almost a Y shape I could see at the back of his head. It might be scars from an old injury and hair doesn't grow there, or maybe a cowlick based on how he sleeps or how his hair. Page 3. My friend kept asking me if I saw red marks on the back of his neck, but I don't remember seeing it. She said she's not sure if she was sleep deprived or if it was actually there, so take that with a grain of salt. Anyone else there, did you see red marks at the back of his neck? Happy to report that he looked really healthy. Unfortunately, I'm going to have to double down on him being small as well. I remember being shocked when I saw him because of how small he is. The pictures that we see online are zoomed up and he looks like a big buff guy. He's really not lol. He's skinny and I would say he's about 5 feet 10. I actually process how much smaller his face is in person versus the pictures that we see. I don't think it's his head that's small, it's his face. He's not a bubble head, but he has like a skinny long face like that one court sketch that just came out. It was actually one of the things that I visibly noticed upon first glance. Someone else please confirm the nose was nosing. It entered the room before he did. He was like 75% nose, but it matches his facial harmony. I thought he had large eyes, but my friend disagreed with me. I remember seeing a lot of white space in his eyes when he would do the infamous PA side eye. Lashes did stretch out for a mile. I could see them from where I was sitting and that was at a good distance. Voice, the infamous voice that started group chats. Haha. I would describe his voice as masculine but not too low. IDK if this makes sense, but imagine you were trying to talk but your mouth was wide open. It's hard to describe voices lol. Some have described it as dreamy, I guess. He definitely enunciates his words, probably because he wanted the judge to understand him clearly. Sounds very similar to the Gilman speech. Hot take, but I don't think his voice fits him. I expected it to be deeper. Don't kill me, but he low-key sounds like a skater boy named Kyle. Like his voice was very calm, crisp and chill. He's got a bit of an accent. IDK if it's an Italian accent or Baltimore accent. He spoke 7 words I have. Yes, I wave. Not guilty. Coming back to the accent, when he said not guilty it was like this not guilty mood/behavior. He was very calm and very smiley. I also noticed that he was curious as well. He seemed like he was taking his own notes and listening intently. BTW, the face he's making in my profile picture is not him mogging to the course. That's his paying attention face. He leans his head up when he's paying attention. He did that quite often. He genuinely seemed like he was in a much better mood than the last hearing, which was nice. I'm sure he's being prepped by his lawyers because him being able to smile with his lawyers and laugh while we are at a literal arraignment for him shows his strength and mental focus. He's a resilient guy and he's not getting nearly enough credit for keeping it together. A lot of us in the room were in shambles and on the brink of tears at the thought of him coming back in with another bulletproof vest and chains. He seemed very calm and once again chill. Consulted with his lawyers many times on things, and before he said I wave he looked at his lawyers first, and they all shook their heads no, and then he spoke. He is definitely listening and following careful instruction. He's learned. Page 4. His interactions with his team were very warm and comfortable. I can infer that he trusts them. His interactions with Sophia seemed a little different. There was a certain openness towards her. This should not be taken as anything disrespectful. He interacted with her the way you would with a real friend. They are around the same age, so that probably makes their interactions more comfortable. I know it would definitely make me feel comfortable to speak to someone my own age. He did not wink at anyone at ISA blatant lie. He did the infamous IDA from the low taper fade PA video many times. Many of the people are claiming that he looked at them. It's true. He looked at me as well. He would lean his head down, do the PA side-eye thing, and then fully turn his head to scan the room. There was one time where he kind of leaned back, did the side-eye thing and then turned his head to look at his supporters. He did this many times, so yeah, he was making eye contact with people. I thought about this later, and it seems like he knew exactly where to look, which is why many of his supporters are saying he looked at them. We were all sitting together on the back left. I don't think it's a coincidence that he was constantly looking in the direction where his supporters were, multiple times. He must have asked or someone told him where we would be sitting because those kinds of seating arrangements were planned out in advance. He has a strong gaze. In general, he talks with his eyes, like he maintains strong eye contact with people when he talks to them. When he looked at me, I kinda had to break eye contact. I'm shy lol. Nonetheless, he was not in love with anyone, and it wasn't an only girl in the world situation. He seemed like he just wanted to know who was a supporter. Like I said, he's curious. I also did not see him eat a sandwich. Another lie. He didn't appear to be chewing anything. I doubt he would want to be chewing and telling the judge to hold on while he finishes his bite before pleading. At the end of the hearing, everyone was told to clear out the room. He was still there talking with his lawyers for a good amount of time. Supporters were some of the last to leave, so we got to stay and watch until he left the room. I didn't see him hug his lawyers, but they were all standing together and one of them could have put their hand on his shoulders and leaned in. This could have looked like a hug. He definitely seemed more comfortable and free being unshackled. Perhaps that's why he was so sad at the February hearing. Random things waiting on the line for a long time means running into a lot of people. Jacob on his team was such a sweet person. He took the time to talk to us when we asked if he was indeed Jacob. He spoke with us and then whispered free Luigi in a cutesy way. He is Loki at the moment. Many of your faves made it inside the room like Chelsea Manning, popular Twitter accounts, Jamie Peck, etc. Also some familiar reporters from the news like Fox, CNN, etc. My friend and I held hands in a hopeful way while LM pleaded to the charges and were visibly relieved when he said not guilty. The Fox reporter smiled at us and found this moment endearing. It kind of threw us for a spin because we didn't know people from Fox could be nice. Renegade for Justice showed up and shared some kind words with people waiting in line. Page 5. Not making any accusations, but Jamie Peck was amongst some of the last people to show up, and she got onto the press line. Remember, easier I said that 20-30 people were brought in and everyone else online was taken to an overflow room. She joined the press line, but none of us saw a press pass. Draw whatever conclusions you want from this. I'm not making any accusations. There could be a reasonable response. I thought I would mention it since people were talking about whether she cut the line or not. This is also really funny, but apparently someone asked her which way to Luigi. I could cry about this one, but I got off the courtroom line and went for a coffee run at like 8 a.m. or something. I went to think coffee and I turned around and saw Jessica Tish walking in with two dudes in a suit. Yes, Jessica Tish, the fishy Tishy. She didn't even order or pick up anything. She came in and hung out for like 5 to 10 minutes and 10 left. I wanted to ask her, were the eyebrows really that wild, but I decided to behave and mind my business. As for the smelly MAGA man saga, karma got him in the end. My friend said he dropped his big huge stack of papers on the floor and was like, oh no, my papers. He didn't make it inside because he was kicked out. Apparently he had so much junk to look through that kept setting off the scanner. Someone said he had weapons with him, so beware. Eventually the court officer got fed up and told him to get out. Final thoughts. Would I recommend people to come to the hearings? I would say yes. It was worth it for the experience. It was an honor to even make it in the room and bear witness to something like this. With that being said, it's not an experience for the weak. If you want to come because he is your Shayla, stay home. I have a good background in criminology and true crime, and I still wasn't prepared for when they started talking about the charges right in front of me. It was a bit traumatizing because you are so used to people saying allegedly to maintain that level of innocence he is owed. But hearing things like murder through the use of a firearm being directed towards him had me shook. Also, I was having extreme anxiety and on the brink of a panic attack because I would have to get used to the idea of him shackled up like an animal. I was on the brink of tears, and so were a lot of people. Fortunately, he walked in without the whole circus and he was in a good mood, which cheered people up. But be prepared to see him like that and decide whether or not you want that image in your head. There are people who still have not recovered from the February hearing. There is no guarantee that he will always be happy and unshackled. He is a person, and just like us, he has good days and bad days. Think about it and ask yourself if you are prepared to see him looking shackled and scared.
So here are a couple of notes I have after reading the actual document itself. Now, this bit I want to say, it isn't me nitpicking or saying, oh, you should change this. No, it's not that. I'm not like grading someone's work here, okay? I don't do that. And if anyone does do that, ask me to give them constructive criticism, I'm not doing that, okay? I will still say it's good. Maybe you will probably need a little bit of work. If you ever give me anything for feedback, I will never say it's bad. So this isn't that. I'm not giving them feedback. These are just things I want to talk about that I find quite interesting. And I actually found it very interesting to read because it's like I've never been in an actual courtroom ever in my life. Hopefully I never will be, unless maybe I'll go to a hearing. I don't know, maybe do jury duty, I don't frickin' know. And also, like, reading through the document, it actually does feel like it's pretty legit. So, again, take it with a little bit of skepticism, but I think it's pretty legit. It is a very interesting read. I do recommend to go read it yourself. Hi, it's voiceover me. So I had this written in my notes, but I totally forgot to bring it up. I was recording this video. One thing I find like really creepy and kind of disturbing is the amount of photos people are finding of Luigi Mangione before he was arrested. Like, I know he had a personal Instagram that I think it was public, and I understand like getting photos from that before like Instagram took it down, but I find it creepy and very disturbing the amount of photos I keep finding of him in his own personal life before everything happened, and I really did not like using the photos the person brought up in the document, what he kind of looked like, and I will never do that again. I just want to show you the examples of what the person was talking about, and when I make these type of videos, I will refuse to use any public photos of the person's personal life, even with Luigi Mangione, and there's so much of him floating around out there. I, again, want to keep his personal life out of this. We are strictly talking about the case. But yeah, I just want to put that here. I forgot to bring it up. Anyway, back to the video. So reading the actual document, I did find it quite interesting is when I mentioned earlier Luigi wasn't in any chains or wasn't like handcuffed or anything like that, and all the accounts people mentioned of what Luigi Mangione looked like in that court hearing, it does sound like very much confirmed he was getting along with his actual like legal team. Reading this does confirm what it was actually like compared to the word of mouth we were getting from some people, what Luigi Mangione looked like, where he was very much wearing a, I guess, beige, yellowy beige type of jumpsuit. He wasn't wearing a jumper with a white button-up shirt because it is a lot warmer in America right now. It's currently spring, I think, over there. Here it's autumn. But that's nice confirming that, what he was actually wearing. And also, another thing I like to confirm, apparently he was in a lot better spirits as well compared to the other ones where he was. But also the other ones, he was very much chained up and very much a show. And I did mention this in my last video where I feel like because there were cameras and reporters around, they very much did it for the show, like the walk they did when they had all the security guards around him and everything, very much using him as a display. When there's no cameras around or anything like that, they didn't do it. So I find it very interesting. I think they very much did that for basically the cameras knowing that, and also confirming his hair is a lot shorter than it was. So I feel like everything we mentioned earlier is more confirmed here. But the thing that made me quite sad when I was reading the document, I don't know why, but when they mentioned Luigi Mangione looks a lot younger than he actually does in all the photos that were shown to us, like in all the other court appearances, and when he was arrested, he does look a lot younger. And I don't know why, it made me feel so sad hearing that. We'll get more into that later on when my opinion part of the video will be. But that bit did make me really sad. It just hit me. So these bits I just kind of want to add. I just generally just found them funny. So one of the lines was, the nose was nosing. And now I think about that on a daily basis. It makes me laugh. Someone commented that the other day and I laughed too hard. It's so funny. Okay, so this is another bit. Again, it just generally just made me laugh when I was reading it, where they were trying to describe what Luigi Mangione sounded like, and basically the line said, "Please don't kill me. He kind of sounds like a skater boy called Kyle." I laughed way too hard reading that. That was hilarious. But like, honestly, they described what his voice sounded like as best as they could. I don't know how to describe voices either. My only reference to his voice is when he said in his first court hearing, and then also when he was screaming at reporters.
Clearly out of touch and insult to the intelligence of the American people.
Honestly, the thing that surprised me the most with Luigi Mangione is his accent. I thought he would have a very like European accent just because of how European his name is, because Luigi Mangione does not sound very American, does it? So I was kind of surprised he had a very, like, American accent, honestly. Also, I found this bit really sweet. Apparently, a couple of times he did look around at his supporters. I think he just legitimately just wanted some faces to the names of people that are supporting him. He did it a couple of times. They didn't say how many times, but he did do it more than once. So this bit I found like really sweet, honestly. So I don't know who this person's like full name is, but in the actual document his name is Jacob. I think he's a part of Luigi Mangione's legal team. So he did help a lot of Luigi Mangione's supporters and some reporters get into the actual room itself, and I found that really sweet. There was a point where he kind of whispers, "Ray Luigi," and I thought that was like really goddamn sweet, honestly. So I think he is part of Luigi Mangione's legal team, and honestly I think that's quite cute. I thought it was really sweet. I do recommend reading this actual document yourself. There is a lot of bits that I found quite sweet and quite nice. It is a very interesting read. I do recommend go reading this document. It was very interesting, very informal for what was happening in the case and how Luigi Mangione looked and how he is. I think it was very good, so I do recommend reading this. If this person ever writes another one, I do appreciate it, and I'll love to read it and bring it up on this channel. So also, you also get to read the bit, "the nose is nosing." I feel like I'm gonna use that sentence in everyday life now, and no one's gonna understand it, but that's kind of hilarious. And one thing I do want to add here, for the person who actually wrote this entire thing and shared it for all of us to read, thank you so much for doing it. You didn't have to do it. You could have just gone and went and not said anything, but it was very lovely of you to write this very good and detailed document and show us all. Thank you so much. I do appreciate it. The 30th of April 2025. So I came across this on Reddit, and apparently a document accidentally had Luigi Mangione's name on it instead of someone else's name, and was officially like fixed. Now, one thing I do want to say here is, so with a lot of these type of places, like in legal places or hospitals or dentists or basically anything involving the government, they do very much still use a lot of paperwork, like paper work instead of everything on files, because for safety reasons. And I can say this from a person who used to work at a place where it was dealing with not with a lot of like documents involving paper, because they didn't want to go through like using it on like computers, because it will be very much easily lost or confused or anything like that. And in those cases, there is literally one person in a room shoved with thousands of paper all around them, and mistakes will happen. I can confirm this. I was that one person shoved in a room going through a million different types of files. Mistakes will happen when it's very much very paper based. I just kind of want to put that here. So places that still very much use things old fashionedly with like hard documents, solid documents, mistakes like that will definitely happen. Please hire me if you ever have a job like that. I would love to do that type of job again. Please hire me if you have that opportunity. Anyway, we're moving on. You're not here for jokes. You're here for sarcasm and facts. That's what you guys are here for. This is the response of the paralegal saying they did not stop listening to Luigi Mangione's phone call he had with his legal team.
Department of Justice, page 1 of 1, United States Attorney, Southern District of New York. The Jacob K. Yates Federal Bureau, 26 Federal Plaza, 37 floor, April 30th. 2025 by ECE, the Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Folly Square, New York, New York. 10007 Re, United States versus Luigi Nicholas Mangione, 25 CR 176, MMG. Dear Judge Gamut, the government writes to amend yesterday's letter describing the handling of a recorded jail call between the defendant and counsel. The earlier letter stated that a Danny paralegal recognized the call as an attorney-client communication and immediately stopped listening. In fact, the paralegal listened to the entire call, then subsequently informed Danny prosecutors about the identities of the people with whom the defendant spoke. Danny thereafter handled the matter as described in our previous letter. Moreover, Danny notified defense counsel of these facts in an email, dated April 22, 2025, thus, Counsel was aware of this information prior to arraignment. The government also writes to inform the court that the United States Attorney for the Southern District of New York, J. Clayton, is recused from this matter. Pursuant to 28 U.S.C. $515, Criminal Division Chief Perry Carbone is acting as attorney for the United States in this case. Per the court's instruction, the government has notified Mr. Carbone of the court's admonition regarding Local Criminal Rule 23.1. Mr. Carbone has conveyed the same to the Office of the Deputy Attorney General, which confirmed that it will in turn notify the Attorney General. Respectfully submitted, Perry Carbone, Attorney for the United States, acting under authority conferred by 28 U.S.C. Section 515 by Dominic A. Gentile, John Zhang, Alexandra Messiter, Thomas John Wright, Assistant United States Attorneys, telephone 212-637-2200, said, Counsel of Record, via ECF.
And oh my god, reading this document was funny as Jay Clayton has been recused from this case, so basically he's not allowed to be a part of this case anymore. But I thought that was important information. So reading the actual document where they basically did not stop listening to Luigi Mangione's call when he was having with his legal team, the person who did that, his name is Danny, and Danny fucked up big time. Like, I have this in my notes just going, ooh, Danny fucked up hard. But basically, Danny, I think his full name's there, but like, I don't care. So basically, he tuned into Luigi Mangione's phone call, and then he realized, oh, it's a actual official phone call. I'm not allowed to listen to this. And then he kept listening on to the actual phone call itself. Now, he's not allowed to do that by law, so I feel like he's been fired. This is how I kind of imagined how it went. Like, Danny, are you listening to Luigi Mangione's phone calls with his legal team? I listened into a little bit and then I kept listening to it. Why? Danny, you fucked up hard. You're gonna get fired for this. Okay. Anyway, that's my stupid little skit of it. I thought it was funny. The 1st of May, 2025, Karen Agnifilo has officially filed her pre-trial motion for the state case. This is about 57 pages. I will make that a separate video because I feel like there'll be a lot to discuss about. So that will be next week's video. I have seen some things coming out of it where I pop onto Reddit here and there to get more updates for things like this, and it is fascinating. So I do recommend to go read it. Hearing the things that are coming out from that actual document is very, very fascinating. Like the amount of police officers that were in the McDonald's trapping Luigi Mangione in where he was comfortably sitting, eating his food. We did see it in writing in my last video talking about the updates and everything we needed about Luigi, and now we actually see the actual evidence itself from one of the actual body cams. Another thing I do want to add here that I find really interesting, again, we'll talk about this document more in depth in the next video because it is very big and a lot of interesting details, I think, is one of them is twice the body cams were turned off. We all know what that means when the police do that. They want to do something sus and not get caught. It conveniently turns off. They're not meant to do that. Another thing I want to add here that's also in the document, again, we'll go in more in depth about this later, but I do find this really interesting and a really big thing, where a female police officer was searching Luigi Mangione's bag, and once she realized she did not have a search warrant to search Luigi Mangione's bag, she put everything back and said she was doing it because she was checking it was a bomb. So that's like a really big thing. So she lied about searching Luigi Mangione's backpack because she didn't want to get into big trouble searching his bag without a search warrant. I will go into this with more detail in my next video where we will go in depth, but it will be in this week's episode if you want to check out the full document itself, or you guys can hang on until next week. The 2nd of May 2025, here are some more documents I want to show you guys where the actual detective on the case for Luigi Mangione is known to plant evidence against other people to make them look guilty. Hi, it's VoiceOver Meme. I forgot to mention this in the video. So this is the document where the detective. He was also there for Brian Thompson's autopsy. I'll put it up on screen for you guys so you have a look for yourselves.
Page 1. Criminal Court of the City of New York, County of New York. The people of the State of New York against Luigi Mangione, M26. Defendant. Felony. Arrest warrant. Ida Joel Siedelman 212-335-4180. Detective Squall Ivers to Dems. Shield 01575 of the Midtown North Precinct. The defendant is changed with 1 PL 125.25. 1. You're in the said degree. 2 PL 265.03. 1. B. Criminal possession of a weapon in the second. Defendant 1. 1 count. 3 PL 265.03. 3. Criminal possession of a weapon in the second. Defendant 1. 1 count. 4 PL 170.25. Criminal possession of a forged instrument in the second degree. Defendant 1. 1 count. 5 PL 265.02. 2. Criminal possession of a weapon in the third degree. Defendant 1. 1 count. On or about December 4th, 2024 at about 6:44 a.m., outside 1335 Avenue of the Americas, in the county and state of New York. The defendant, with intent to cause the death of another person, caused the death of such person. The defendant possessed a loaded firearm with intent to use it unlawfully against another. The defendant possessed a loaded firearm outside of his home and place of business. The defendant uttered and possessed a forged instrument of a kind specified in Section 170.10 of the Penal Law, and particularized below with knowledge that the instrument was forged and with intent to defraud, deceive and injure another. The defendant possessed firearm silencer. The factual basis for these charges are as follows. I have reviewed surveillance video depicting the exterior of the Hilton at the above location, specifically a camera angle depicting 54th Street, Berwyn, 7th Avenue and Avenue of the Americas. In the surveillance footage, at approximately 6:44 a.m., a man. Page 2. Criminal Court of the City of New York, County of New York. The people of the State of New York against felony. Arrest warrant. Luigi Mangione, M26. ADA Joel Siedelman, 212-335-4186. Defendant wearing a distinctive clothing outfit. The shooter approached Brian Thompson from behind, and then the shooter held what I recognized to be a firearm with a silencer attached at the end and fired it several times at Brian Thompson, causing him to collapse on the ground. I am informed by Detective Oscar Diaz, Shield number 4656 of Manhattan South Homicide Squad, that he was present for the autopsy of Brian Thompson and that the cause of Mr. Thompson's death was determined to be a gunshot wound to the torso. The defendant is the person shooting and killing Brian Thompson in the above described surveillance footage, based upon evidence collected during the investigation, including, but not limited to, surveillance footage that I have reviewed from the High New York City Hostel at 891 Amsterdam Avenue, which depicts the same man, wearing the same clothing, leaving the hostel on December 4th, 2024, at about 5:34 a.m. Surveillance footage that I have reviewed from that same hostel that depicts the same man, checking into the hostel on November 24th, 2024, at about 11:20 p.m. and showing a driver's license upon check-in. I have reviewed business records from the hostel that showed that the man provided the New Jersey driver's license with the name of Mark Rosario on it. 1 a.m. informed by Detective Diaz that he is informed by Patrolman Tyler Fry, badge number 351 of the Altoona Police Department, that on December 9th, 2024, at 9:58 a.m., defendant was taken into custody at the McDonald's in Altoona, Pennsylvania. That defendant presented a forged New Jersey driver's license with the name of Mark Rosario as his identification, which based on the number on it was the same identification defendant presented at the hostel, and that in defendant's belongings. Patrolman Christy Wasser, badge number 250, found a semi-automatic pistol with what appears to be a 3D printed loaded receiver, with a metal slide and silencer, and written admissions about the crime. Page 3. Criminal Court of the City of New York, County of New York. The people of the State of New York against Luigi Mangione, M26. Defendant. Felony. Arrest warrant. ADA Joel Siedelman 212-335-4186. Falmira permade in him in he Peter punishable or Class A.
but you can see there's very much a lot of things that are very sketchy in this entire case as we go on. This is a request for a status conference for Luigi Mangione's case, and I can't really find the full document why they're requesting this, but remember we said earlier if Karen wanted a status conference or anything or more time, she can literally like request it, but I'm not sure in this who requested this, but this is very, very fascinating. This very much came out a couple of days after we got that 57-page document. So basically those are the last really big updates as like recording this video that we have so far for now for Luigi Mangione. These are my final thoughts about all the information we have so far. Again, I will go through that 50-page document Karen has written for this in my next video. Anyway, so this is my like final thoughts of like from all the information and everything that's been given to us so far. So it won't be as big as the last one because we don't really have any like fake news floating around. Maybe there is, I'm just not looking for it, or it's not bluntly obvious. This is more so my final thoughts about everything. The thing I find most interesting the most is how much the police and the prosecutors have fucked up, and a lot of the things that are kind of confirming as we learn more and more information about the case going forward is from like the very, very beginning. There's been a lot of sus and sketchy things going on with the police and the prosecutors. Like, they've been doing so many like illegal things when everything they've been doing has been very sketchy, very sus, and we're getting a lot more evidence like shown to us as the public. All of our like skepticism and more as it goes on, it very much goes on as it's confirmed. A lot of that will be covered in the next video. And another thing I want to add is in a lot of photos we see of him when he's being arrested or when he's walking into the courtroom of his first hearing or his second hearing, or like any time we see pictures of him, the looks on his face when he's trying not to pretend it's not getting to him, he looks so scared. And then also other photos we see of him, it very much looks like he is trying to hold it together, pretending it is not getting to him. Like where he was first arrested and they wouldn't let him go to the bathroom, he was very much holding his head high, pretending it wasn't getting to him. But seeing the pictures when he's letting that slip, he looks so scared, and it makes me feel really sad. Like, I'm very much like sympathizing with him. Like, he's not that much older than me. Thinking about that the other day, like, man, he's not that much older than me. He must be so scared. Like, I feel like a scared 16-year-old all the time. You still very much feel like a child in your 20s. Like, you don't know what the fuck's going on. You're meant to know. You don't. Like, he's not that much older than me. It must be such a scary thing to go through all that. That's why the bit where it said earlier in the document, oh, he looks way younger than he actually looks, really got to me. But I do think things are more heading towards things for the better for Luigi Mangione, like for his case. But I don't want to speak too soon about it. It's just my personal opinion of how things are going with all the facts and all that. They are like my major big thoughts about it. I do appreciate very much about the person who wrote the document being in the actual courtroom itself, because again, cameras and stuff weren't allowed in the courtroom, so I do very much appreciate the very well written document for that, and I'm glad I'm able to make this little silly podcast so I can just keep all the facts straight and all that for you guys. So please keep your eye out for next week's episode. We will be going through Karen's pre-trial state motion. Keep your eye out for that. I feel like there'll be a lot to talk and discuss about that in that type of video. Thank you for watching this week's video. All these sources and everything I looked at in this video will be on this week's episode, so please go check it out if you want to see it. My little website there is just basically so all the sources I've used and everything for these videos is all directly in one place instead of you guys have to scatter and look around everywhere. And also if there's like anything I got wrong or missed or anything like that, please let me know in the comments down below. I'll sure to bring it up in my next video or even just pin the comment. Thank you for watching this week's video. You can subscribe if you want to, it's okay. If not, I upload every week, sometimes 3 times a month. Depends what I'm working on. If you guys want to keep up to date with the channel, you can follow the channel's social medias. That's where I just post little updates and little behind the scenes stuff of what I'm doing with the channel or what stories I'm working on. That's mostly where I post it, and that will be in the description down below. If you guys want to follow me personally, all my social medias are down below as well. Please take care of yourselves, and I'll see you guys all in my next video. Bye! This hobo is giving me a goddamn migraine. It was cute, but ow my head.